But
All right, we are back to Senate Judiciary, February 13th, S44. Ledge Council was able to come in and just provide with some new information about S44.
good morning, Rick Sable, Office of the Council. You all had a few questions last time that I researched. I got some answers to. One was about the special session authority. I think Senator Husky, as to what the governor can and cannot do and what the assembly can and cannot do. My understanding is that the governor typically sets out an issue like the mask mandate, that kind of thing. In 2021, that was the last special session. And in his letter to the assembly said, this is the issue I want you to take up, and specifically the masking and the town ordinances revolve around masking. And in the letter, he indicated that he would veto anything else that was not related to the mask mandate. So,
but we weren't constrained legally from pursuing that.
you know, it's in the Vermont Constitution that the governor has the authority to call the legislature right into a session. So, I didn't see, it would take further research to see what would happen if the assembly did pass something unrelated to the governor's request, and then the governor either did not veto or was overridden on a veto. That would be interesting, as to if that's happened before or not. But my understanding is that the assembly could go off on a tangent. However, not sure. Obviously, the governor would veto something that.
Well, this governor has said that that's what he.
In general, right?
Generally.
Yes. In general, governor would have the authority to veto legislation that he or she doesn't agree with. And as far as the special session, I don't think that changes anything.
And am I correct that the special session goes on as long as the legislature says it does?
Correct.
That all tracks with my memory of the one you're referencing, because there have been a couple of times where the governor has tried to indicate that the law constrains us to one topic. Secretary Bloomer has always been of the opinion, as was Ledge Council then, that is wishful thinking on his part. Once he calls us back, we have authority, then that's countered by his authority to be done, which he threatened in that instance. But
Senator Wilson.
So I guess the governor calls us back, and then it is essentially just the same. So we can end that special session with the caveat that we come back for vetoes, et cetera, et cetera.
yeah, because we would have to adjourn the CNDA again to lose that.
And this would be a very interesting use of special sessions, you know, because there's a whole 60-day requirement thing that the governor must provide public hearings and provide the assembly the agreement 60 days before the assembly can even vote on it. So there had to be some planning here, because I don't think the governor would call you into session and then give you all the agreement. I assume there'd be some kind of way to give that to you before you were called into session. And if he didn't act on it, if he didn't vote on it, he just could keep you until something was done. But
that 60-day provision still seems excessive to me, in terms of him having to present a plan 60 days, 2 months before we would act on it.
But also, how could he keep us this is where I keep getting hung up, is so the governor calls us into special session. It sounds like we do have to come into special session, but then if we decide we don't want to act on it, would we just sitting around for 60 days? Because how does he keep us here?
Well, it would also apply in session, right? So theoretically, he could notice files in early February of something with an intent to enter one of these agreements. And then in April, we couldn't act on it until April. And that's what I mean. It's not, it's an important issue. Doesn't seem super complex if the governor wanted to say that these law enforcement agencies in the Franklin area, let's say, or the border area, are going to be under this agreement. Seems like in 30 days we could get up to speed on that, vote on it, act on it, etc.
But the language still is we may act, so we
Yeah.
could just do nothing and then what, we're held hostage here?
So to answer your question, the governor could just call you back
Every day.
If you adjourned, you could just call another special session. That's kind of was my point.
So I understand what you're saying, and I don't know if I agree or disagree with it. But I'd like to, like, for instance, say maybe Jay can extend a little light as to Johnson as to why the 60 days is so important versus why can't we do 30 days? That's all I'm saying here.
Whose bill is?
Senator White,
Yeah, so I think what she was trying to do was, and within the bounds of the law, defer the governor's ability to act as long as possible. Whereas Jay Johnson would probably say there can't be any delay on the governor's right to act in an emergency.
Which kind of makes sense for whoever's sitting in the governor's chair.
Right. Question would be, is it, you know, Donald Trump in Washington is saying that the border crisis is an emergency. And so we can move around all the rules, including, you know, deploying different sets of troops to the border. But here, it's hard for me to believe that it would be abused to that extent. On the other hand, the whole point of the bill is to try to make sure that the legislature has a function, which I really support. I think, given what we're talking about, and how far it's gone nationally, I think state legislatures have to start stepping in and declaring what they think and what their powers are. But yeah, the 60 days I think was just Becca trying to get as much time between the announcement of the intent to act and it going into effect as possible. But probably Jay Johnson would go the other way and say there has to be 3 days notice or something.
And so what's the happy medium in your mind? The compromise in your mind?
I feel like, you know, if it is an emergency, you know, like a flooding emergency or something like that, the governor is empowered to act very quickly. I just would want to make sure that that power isn't abused, calling things an emergency when they're not. But if it's not truly an emergency and it's just a desire to enter into these contracts, then it seems like 30 days would be plenty of time.
I still have I'm having a hard time wrapping my head around what any type of emergency that would require entering into these contracts. Like, that's where I'm really struggling. Like, I get it. We need the governor to act quickly if there's a pandemic or a flood, but I can't put my mind around what type of emergency would require one of these contracts immediately.
Well, let's let Rick continue on with his testimony so we can get some more information before.
Any more questions about the special session?
Can we not come?
What's that?
Can we decline to come?
If you just decline to attend a special session, that could be a constitutional crisis because the governor has the authority to call you in. If you just don't come, there may not be a clear path forward. You also asked about state employees as far as could ICE deputize non-law enforcement? Probably not, because ICE does require certain levels of comment. You may, I don't have the website pulled up, but on the ICE website, you said they have to go through these various checks, not just background checks, but also just carrying out police activities. So in the statute, you clarify and say it includes all state employees, not just law enforcement. But my belief is that the way that this already works, it's not going to happen. ICE would enter into these agreements because these state employees would not have law enforcement training. They would not be able to carry out these duties that ICE would also carry out.
But if we were to get to some future space where those things changed, then yes, they could deputize state employees as the bill currently reads.
It would, so the federal law is not specific. It's kind of defers to state law as to what the states allow. So, you know, could a state, not Vermont, could another state say, if we accept, we're going to allow, you know, all peace officers or other non-law enforcement to carry out these duties because we're short on staff or whatever, possibly the state specifically allow that. But ICE would still say, well, these people need to have certain training, minimum competency, right? Which,
Today, they would say that. We don't know what the, like, there's nothing currently in state law that prohibits state employees. So my understanding within the flood bill, we actually changed some of the language around the governor being able to deputize state employees because it was broad scale. That went through a lot of iterations. And so I don't know if that made it all the way to the end. And I certainly understand that there are qualifications presently for whom ICE would choose. But I am concerned that that would change. And want to make sure that our state law is broad enough that it protects for future possibilities.
I'm not quite sure if ICE is gonna invoke posse comitatus, state of Vermont here, so that's a concern, obviously, but yeah, I think they're more professional than that.
Although I have to say,
A lot of wild things have been happening.
Yeah.
Trump is making it clear that he wants to have his own, I don't know what to call them, domestic forces. Like, he's looking at, essentially officers from Homeland Security as his internal force, and then ICE as connected to them. And, I don't like the direction that's heading, and I wouldn't have thought 5 years ago that those were possible.
And I imagine the Germans didn't think people were going to be brought in to round people up. Like, I really understand that the way we currently sit, but I sit with you in a space of like watching what's happening and wanting to protect for any possibility.
Rick, do you want to continue?
I have one more question. It was about, and I think the governor even addressed this in his press conference about whether it's the exclusive authority of the executive branch to enter into these agreements. I believe the governor said that it would be the governor's sole authority. And it is because that's what the assembly gave him, or gave that office 8 years ago. So the federal law even says subject to state law, like you can enter into these agreements subject to whatever the state decides. States are police power, as far as the Constitution goes, and the state gets to determine how it executes law enforcement for the most part. So my belief is that the governor has the authority because you gave it to him. You can also change it and require the assembly be involved. There may be some arguments that could create separation of powers issue, but I don't see that as far as the federal law is concerned. I don't see that as a problem personally. But
Is there in which statute did we provide in that power?
this is the 20 ESA 4652.
There was some. Yeah. Okay.
And there may be another statute, Mr. Chair, where the assembly has done something differently as far as the governor's authority to enter into a certain federal agreement that's not ICE related, right? But in this specific instance, the state is allowed to kind of dictate the terms of it.
Wait, so just to clarify, you said that we provided the authority to allow us to dictate the terms, but not dictate whether or not it can be entered into, or both?
So the current law says that because let me take a step back. The federal law allows ICE to enter into these agreements with state or local law enforcement, subject to state law. That's what the federal law says. So Vermont, 8 years ago, said, yes, we will take these agreements with ICE, however, the governor must approve of them. Like, not many states have done that. Vermont did that. So now, and that's current law, that's not been challenged. Now, the suggestion is the governor can still be the one person who does that, but his check on that power is the assembly's ability to up or down a vote on that kind of agreement, if that makes sense.
The draft.
That's what the draft says. And then there's a whole 60-day thing, that's addition. Yeah.
Senator Matos, you had your hand up, and Senator Ruth.
No, just answer.
So philosophically, I would be all for trying to add to the statute a check from the assembly practically speaking, I think you're right, Mr. Chair. I don't see a bill moving forward that gets the governor's signature. And I think that they would fight that tooth and nail.
Yeah.
So what you had suggested, which was constraining law enforcement agencies. But it seems like that's already built into what we have, right?
I don't believe that we can constrain what agreements they can enter into the 287 agreements, or maybe I'm incorrect.
Yeah, so this current law, not the bill, just the law, it says that before any town, county can enter into 287 G agreements, the governor must approve of it first.
So in other words, I don't think if we follow that practical line of thinking, there doesn't seem to me to be a path for this bill because it all terminates in the governor's current authority, which he'll detail and protect.
And towns, when it comes to the towns, the attorney general also has to advise.
Consult, right? The governor must consult with the attorney general.
If I might, I'm sorry, go ahead.
Did you have your hand up?
I do.
Oh, please.
But I recall from your testimony last time that consult is rather vague and doesn't have a whole lot of meaning. Like the governor could call and leave a voicemail and say, "Oh, consulted with the attorney general."
Right.
So, yeah, but I don't know that actually means anything.
I would, and maybe I was too flippant with that. I think the governor would want to have some record of that consultation more than a voicemail. Just, this is maybe not necessary, but there is consultation does have a term. I mean, not a defined term, but it does mean to speak with some kind of communication, right? Besides the voicemail or email. But if the attorney general never got back to the governor, then that would not be necessary to have a full conversation with the required.
And no agreement is required.
Correct.
So the attorney general could say, absolutely not. And the governor could say, cool, I consulted, I'm doing it anyways.
That's correct.
I guess it's the power of the governor, speaks again, but I think this was sometime during, and I may have to research this myself, find someone intern, but fair and partial policing policy, I believe came into play there. Basically the same time. I think that was mentioned in there as far as that may have been part of the procedure. So I'm curious as to review. I was involved in the fair and partial policing at the academy.
Yeah, that's what I know. Other than that, I don't have a good understanding of that area of law. But yeah, these two things were done around the same time.
Yeah, the 287 G, I think was mentioned during that particular agreement.
It would be interesting because I know the fair and impartial policing policy was recently updated. So I do wonder how that would interplay. I don't know all of the details of that update, but I believe it was updated just in April or May of this year, or last year, I guess, technically.
Yeah, I think perhaps we can get the Criminal Justice Training Council on the list as a witness for next week, just to get some information about that. And yeah, and to reiterate Senator Ruth's point, like to work on a bill that's passable. And at least historically, I have often agreed with how the governor has approached immigration issues. It's not to say there's other areas I disagree with him, but I don't see this as, at least with how it's written right now, I don't see this as absolutely vital. But I do want to figure out how, or what other steps we can take to strengthen immigration protections in the state. So I think we'll have the Criminal Justice Training Council come in and talk about the fair and impartial policing policy and see if there's anything we can do there. Senator Phillips.
I appreciate the concern and I do think it's important that we be thinking about not a specific person in a role, but any person that could be in that role. And so it's great that you agree with this governor's historic immigration policy, but we have no idea what someone else's immigration policy would be. So I do think we should refrain from making policy that is specific to a person in an office, but more the power of the office and how could that be used or abused.
I don't disagree, and I was thinking of that as well, but regardless, I mean, yeah, that is a concern. We could get, who knows, in 2 years. But also regardless of who might be sitting in that seat in 2 years. I don't think that this bill is one that would pass with the governor's signature or without it. So
And our, you know, if I might, our biennium, he's the governor, and so
Yeah.
that's all I'm thinking about. But I did want to ask, we passed last year or the year before, we passed a bill that protected people who are undocumented, who went to courthouses to testify or to participate in some kind of legal proceeding. And as I remember it, the statute said that they couldn't be arrested on their way to or from the courthouse. And I know the president has now signed an executive order allowing ICE to go to schools and churches and arrest in those environments. So I'm wondering, first of all, does our rule on courthouses still stand? And is there room in the interplay between the federal government and the state government for us to protect schools, churches? In other words, do we have the power to contest that executive order at the state level?
So I'll give you kind of a general answer, and then I can come back with some specifics that maybe are updated based on the recent executive order. So generally speaking, federal law is going to supersede state law when it conflicts, right? So if the state, and I'll look at this bill about the undocumented witnesses, but if you have a state law that says if you are documented and these are a protected place, church, school, courthouse, state police would have to respect that. And they would not be able to execute any warrant or anything based on that. However, ICE, if they entered the state, they would not be subject to the state's definition of sanctuary city. So, this law. Could state officials coordinate with ICE in violation of state law? It's a tough question. If ICE, talks to a sheriff's department and says we have this person who we believe to be a criminal, and they're going to be at this courthouse at this time testifying, it's a tough one. I would have to research that, but I think if ICE came and did it, that would be something you couldn't stop. But if a local state law enforcement did it, I think that could be something that the state law would prevent, if that makes sense. Yeah. But I'll come back with this new executive order and see the play on that.
Senator Wilson.
So a couple of things. One is, in this hypothetical, we're talking about if that state entity had been entered into one of these contracts, could they then do what we're talking about in violation of state law? Because now they're working for the federal government, not us.
That's kind of the gray area.
Okay.
Yeah, that's kind of what I need to learn more about.
Okay. The other thing, to Senator Marie's point, it's actually a drafting request I have in that might go into this space or maybe somewhere else. It's actually an expansion of our Good Samaritan laws. So currently our Good Samaritan laws, as many of you probably know, if someone calls for help, they call the police, they report an overdose, they go to get a substance they have checked at a drug checking facility, they can't be arrested. One of the things I think we could do to expand protection would be to add that they also can't be reported to ICE in those instances. Is that correct? That is something we could do that would expand protection for people asking for help?
So yes.
Okay.
Kind of like with the bill you passed for the witnesses, right? Similar thing that the state law enforcement would have to respect that law, but federal law enforcement would not.
Of course, and I imagine, I don't see where it would play in, because the sort of language is that they can't be reported to ICE, but if it's ICE, they don't need to be reported to ICE, they're ICE.
Right.
So my understanding is, I think, kind of to what you just said, is that the state police or a sheriff's deputy can't call ICE But if ICE were to call the state police and say, hey, have you encountered a person? That officer, state officer or deputy has to answer those questions. So I think that's,
It would depend how the law is written, right? I would have to, yeah, if it says no coordination, or if it's very clear that there cannot be any communication, then probably yes. But if it's not as clear, then possibly there could be a backdoor way for the law enforcement to contact ICE.
And or that gray area.
you were,
It's,
yeah.
there's a lot of gray, you know, unfortunately.
Yeah, well, and so the Good Samaritan case, the instance I think about the most is in instances of trafficking, where someone is being trafficked, held against their will. They are undocumented, or their documents are being held from them. They call, they ask for help, now they're reported. I want to prevent that. And the Good Sam law was a space that I sort of saw. And it fits in line with what we were trying to do, right? We were trying to make it safe for people to ask for help or be safe or report something. And so that's, but I do want to be really clear. And I don't know if you have, I don't know who has the drafting request. Because I thought it's Ben, because I thought it would be him.
The problem's been.
Okay. But I do have a request in, and I do want to make sure that there's like clear conversation about making it as tight as we can. But that was one place, Senator Ruth, where I thought we could actually kind of expand in
Yeah.
the area you're talking about.
Senator North.
We had a committee discussion that, I'm not sure where it's all set down here, but I think your concerns are addressed already in fair and impartial policing policy with reference to a victim of a crime or a witness to a crime is protected under that particular. It's clear, it's succinct, your interpretation of it, you may not like it, but it's in there, it's what it says, okay? In the fair and impartial policing policy. So my concern here is, I understand what the senator's saying. I also want to duplicate our efforts. Once again, going back to the FIP, let's have somebody come in, take a look at it, and see if those concerns are addressed. And I think you hit, your assessment was spot on, the reference to 44. Just so you know, I'm not sure that I'm really overly excited about any type of law enforcement going into our schools and quite possibly traumatizing elementary and to go along with churches also. You know, there's a fine line there, and that may be pushing it somewhat. So, but I mean, how much authority do we have there from a state versus federal standpoint?
Yeah.
Senator Rose.
Yeah, I respect that it may be in the fair and impartial policing policy. And again, I think it's important to get that updated, and I don't think it's duplication to codify it into law, because we have no control over what is in the fair and impartial policing policy. That could change tomorrow. Probably won't, but it could. So I absolutely want to hear from the Criminal Justice Council. It also might be helpful to hear from Migrant Justice, given that, you know, we are all documented. It might be helpful to hear from a group representing those who may not be, or those who are, you know, as we heard from Jill, Martin Diaz, are at home afraid as to what they need from us.
Thank
Well,
you, Rick.
those are the questions I had from last time. So
Now you have more.
That's helpful.
I have a little bit more.
I think it provided a lot of clarity and realistic idea as to what we can and can't do for now. Maybe that'll change after some months as we use. But yeah, thank you for coming on short notice. I appreciate it. Committee will be back at 10:30 for S45, the